The 16th of July 2026 in rural Ireland, and it's a lovely day today again. We had a lot of rain now over the last few days, but it's lovely now again. Now, I've called this Monivey because it's relevant to the Monivey action group in Galway over the solar farm, but it's general. Don't just switch off on this because it's interest to them, but it's also interesting to you people, because this morning I bought the Irish Independent. I know you'll give out to me for that. I bought the Irish Independent, but I want to show you a notice in it. Now, I don't know, can you see this there? Can you see it down? See that? Understand? Now, you will know that I have been waxing lyrical, bleating on for years and years about the lack of an SCA for the various government plans or programmes. And you may suspect that I'm talking through my hat and all of that. But this notice, which is a foot long and it's easily 6 inches wide, states as follows. And this, don't please switch off, this is interesting. 5th Nitrates Action Programme. See that? A government programme. 5th Nitrates Action Programme. Notice the following relates to the measures that were introduced under the 5th Nitrates Action Programme on the 25th of February 2025. The notice is now being given following the publication of the associated SEA statement. The associated SEA, that's Strategic Environmental Assessment, right? Why now is this there? Do you see, is this not backing up what I have said all along? In accordance with European Commission implementation decision for Ireland's 5th Nitrates Action Programme. What's in the SEA directive? Plans and programmes. I've given you the thing before about planning. At the bottom is the development for a house or a swimming pool. In the middle is a project for a wind farm or a small piggery or whatever. And the next on top of that is the SCA, the public plan or programme. Okay, we have that right now. So now, Statutory Instrument 113 of 2022, European Union Good Agricultural Practice and Protection Waters Regulation 2023. Okay, nothing there. Now, watch this. Article 9 of Directive 201/42/EC of the European Parliament and of the Council of the 27th of June 2001, that's exactly what's on the top of the SEA directive, on the assessment of the effects of certain plans and programmes on the environment in accordance with the European Community's Environmental Assessment of Certain Plans and Programmes Regulations 204, Statutory Instrument 435 of 2004. That's exactly what I've been telling you. If you go back looking at the videos, that's the statutory instrument. So Val is not so far out. Here it's in the paper. That's today's paper, the 16th of July. As amended by the European Environment Plan, Certain Plans and Programmes Regulations, Statutory Instrument 200 of 2011. Okay. The Department of Housing and Local Government and Heritage hereby gives notice of the adoption of the 5th Nitrates Action Programme, that 2002-2025, additional measures on the 25th of February 2025. It's giving notice. If they had done it for the renewable energy and all of the housing and everything which they're legally obliged to do, this notice would have to appear in the paper. A copy of the associated SCA environmental report. I'm going to underline this for you here, folks. See that? Now I'm going to read that for you again. A copy of the 5th Nitrates Action Programme, additional measures and associated strategic environmental assessment, in brackets SEA, environmental report, Natura Impact Statement, and appropriate assessment AA determination, that's appropriate assessment under the Habitats Directive, and SEA statement are available for public inspection, excluding public holidays, at the offices of the Department of Housing, Local Government and Heritage between 9 and 5 p.m. The documents are available for viewing by emailing the email addresses wau@housing/government.ie. These documents are also available for inspection on the website of DHLGH at government.ie publication Nitrates Action Programme 2022-2025. The following points are summarised: how the environmental considerations have been integrated into the fifth programme, how the environmental report, see that, prepared pursuant to Article 12 of Statutory Instrument 435 of 2004. There you are. As amended. Submissions and observations made to the competent authority. You're entitled to make submissions to the notice. To a notice under Article 13, there has to be public participation. Any consultations under Article 14, Statutory Instrument 435 of 2004. That is precisely what I've been preaching for years. Have been taken into account during the preparation of the 5th Nitrates Action Programme measures. The reason for choosing the 5th Nitrates Action Programme additional measures in the light of other reasonable alternatives dealt with. They have to show reasonable alternatives. The measures decided upon to monitor in accordance with Article 17 of that Directive 435 of the Statutory Instrument of 2004 as amended, the significant environmental effects of the implementation of the 5th Nitrates Action Programme additional measures. In accordance with Article 6.3 of the EU Habitats Directive 92/43 EC, an appropriate assessment of the 5th Nitrates Action Programme measures has also been undertaken, and the NIH and AA, that's a Natura statement and appropriate assessment determination, are also available for viewing at the same locations. Signed the 16th of July on Rin, Department of Housing, Local Government and Heritage. There is the clear proof that what I have been saying about the law is right. Here they're doing it for the Nitrates Directive. They haven't done it for river basin management, for silviculture, which is forestry, for town and country planning, which is all their housing plans, for energy, the wind energy, the solar energy, the north-south interconnector. I went to the High Court and was shot down by Judge Max Barrett because he said Bord Pleanála couldn't refuse the permission. All that energy. Our data centre should have been assessed. There you are. So isn't that proof? So how can the Irish government say there's no SCA needed when they're doing one? Where's their SCA for offshore wind? Where's their SCA for onshore wind? There's none. Where is the wind energy guidelines of 2006 assessed under the SCA directive? Groups fighting wind farms and solar farms must get to understand this. And this must be one of the grounds in any judicial review. The result of this is that we have utter mayhem in the energy sector, utter mayhem in the housing sector. They're deciding now to cut the size of maisonettes. Now, unfortunately, immigration is not on it. But why are we not insisting on what is on it is assessed? There has to be a notice in the paper. You have to be entitled to make your submissions when all options are open. You have to be given reasons for the decision. And then when all is done, they have to publish this statement. There is an environmental report now, and if you send in an access to information on the environment request. Now, the man in contact with me over the solar farm in Galway is Tom, and I'll help with the access to information. the first thing I'd be doing on any of these is get in your access to information to this Department of Housing, Local Government and Heritage, and they have to send it to whatever other department if you don't send it to the correct one, and ask them for the environmental report on Ireland's energy policy, its Renewable Energy Action Plan and subsequent plans, and ask them for a copy of it where it deals with solar farms. 900 acres to be covered in Galway of good land. They haven't got it. I'd get the reply from them and see what they say. Isn't that good? How can you argue with that? If you open a pub and no licence, the guards will come in and you'll have to shut it down until you go through the whole process. Nobody disputes that. And yet here it's been blatantly ignored. And I have if you look at all my videos, that's the directive there. 2001-42 EC. Not only that, this will now legitimise planning applications, etc. This will form the framework for then anything that involves the nitrates and nitrates disposal, sewage, council sewage works and all of that. So this sets the framework. This is the strategic planner programme. There it's there. For Nitrate Action Programme. You see, this is the strategic planner programme for the whole country, and this sets the framework for the what do you call it, the project, the local applications that will be taking place, and that means the planning authority in Limerick or Westmeath don't have to deal with this. This is done. This is all done. So you just apply your environmental report and then you apply for the project under the local conditions. And that's applied for under Part 10 of the Planning and Development Act. Any environmental impact statement, any EIA, which does not have an SEA, is invalid if it's for the industries mentioned in Article 3.2. So that's where you start off with all this junk. So there's your evidence. So that's evidence in a court of law on its own. The Irish Independent. Folks, I'll see you back. That notice, it's about 13 inches high. Look at it there. No, sorry. No, look at it there. See it there? Now, they'll say, we can pick and choose. We'll do it for the nitrates. No, you cannot pick and choose. It's all public plans and programmes. And under the SEA directive, there can be a modification. So when they did it for the renewable energy, they can then come out with a modification. So there might be some part of this not covered. We'll say some part of it. I won't name it here because I'll leave myself open. But we'll say it's containers for slurry or containers for foul sewers or containers for disposal of sewage. And it's not covered in this. That's all right. But they cannot go ahead for planning permission until they get the modification done. This only covers whatever is in it. And then they go along and they do the modification. So when they did it for renewable energy, the wind energy guidelines should have been done either with the main SEA directive or as a modification to the original one. And when they made the modification, then the very same conditions applies, but anything already agreed and all is finished. This can now, if they've issued this environmental report, there can now be a judicial review taken on it through the courts up to the EU. This can be challenged if anyone wants to challenge it. And once it's challenged and finished and the legal part over, then it's done. You can't revisit it without the permission of the government. That's it. It's done and dusted. Get me a point? I hope I've made that quite clear. It's great evidence. There is the evidence. Clear and concise. And this is for everybody. Now, I don't mind any, anyone can put in any comment they like here, but I will delete nonsensical ones. Now, I'm going to start with my videos if they're on specific stuff, like particular law and that, or particularly on planning and that sort of stuff. I'll delete the buckos. The buckos are putting in stuff here, and it's not on, but there will be videos where they can put in what they like. So we let you go. Thank you very much. Comment underneath. And isn't that the proof? There's the proof that I was right. My father, God be good, used to shake hands with himself. This is the law. We have them beat. I told you before, there was a time in another walk of life, I'd know when a case was solved, and I'd know when we had it beat. We have them beat. If the people will just listen to common sense and go along with a wee bit of guidance, and people come to me for various planning things and other stories, and I like to help. I'm doing this for the good of Ireland, for the good of my environment. We'll see you back. Good luck, and thank you very much.